A person, when they're injured at work, their income stops. If they're not getting benefits, if their bills are piling up and they don't have any income, and we're in a claim petition proceeding, that presents one set of challenges. If, on the other hand, they're receiving benefits and the carrier's going after them, they got a doctor to say they're better and they're trying to cut them off, that presents a different set of challenges. So you have to, react with what's on your table at that particular case. Now, sometimes you don't want to settle the case. Sometimes the person's condition and their situation is still fluid, is still pretty unpredictable. We don't know what the future holds. The surgery may be happening later, and maybe that case isn't suitable at this point for mediation. Or maybe it's suitable for a mediation that doesn't end the case. Mediation doesn't, from my perspective, it doesn't have to end everything.
Because there are a lot of issues. You may knock out 5 or 6 of the 10 issues that have to be settled.
That's happened with some of my cases where a lot of times an insurance company will accept the claim. I have a case where a guy had several shoulder surgeries, other surgeries, really bad injuries, and the notice of compensation payable says strain. Okay, it was way, way worse than the strain. So one of the things we resolved in a mediation, we didn't settle the whole case, but they sat down and I said, okay, we have these operative reports. Define this injury correctly. There was a torn rotator cuff. There was other specific things that were done, a ruptured bicep that had to be sewn back together. Define the injury right. Insurance companies will try to get away with as sketchy a definition as possible so they could dodge bills, so they could dodge responsibility later. I hate to make it sound sinister, but they're in business to make a profit.